Live?
Whenever his stuff slows down.
If ever. Okay, here we are live from Washington, D.C.
All participants are now in interactive talk mode.
Very good. Hello, everyone. Hello. Hello, and
Hi, Paul.
welcome to our second session. Hopefully you will find the audio greatly improved from last time. If not, please email us immediately. We have Don Wasserman, the former Director of Research and Collective Bargaining, here tonight. Hello.
Bow.
And a bow. Couple of business items first, but very quickly, and then I think we'll go around the room so you know who's in the room here, and then hear from the folks who are. Are we live so we can hear people from who've called in? Okay, but we'll do. The next date, we are planning to have Gerald McEntee as the co-professor, and the date that you have may be subject to a little adjustment, but count on it being the original schedule. But if it'll take a little adjustment to get Jerry back up here, I think we'd all benefit from that. So we'll give you plenty of notice if there's going to be any date change. I don't have any other preliminaries, so I think it'd be Don's benefit if we go around the room, people say who they are and what department they work in, because not all of you were there when Don retired. So I think you'd get a big kick out of that. So,
What are you doing here?
I think I've lived through the last 30 years here at AFSCME.
So Barb, why don't you go first? Barb Sofel, and what department you're in?
Barb Stoffel from Federal Affairs.
See, it's a new name, Federal
Yes.
Affairs.
I
Yes.
see that from the blog.
Yeah.
Katie Coakley, Information Services.
Joy Barksdale from Communications, used to be Public.
Amy Hendrick from Communications. Karen Tyler, Auditing.
Jessica Robinson, General Counsel's Office.
Doug Burnett, Political Action Department.
Jillian Matundin, Organizing and Field Services.
Jane Carter, Research and Collective Bargaining Services.
Lisa Martin, the President's Office.
Jeanette Chavez, the President's Office.
Cynthia McCabe, Communications.
Justin Burchard, Political Action.
Seth Johnson, Political Action.
Gary Stores, Research and Collective Bargaining.
Sam IS Department.
And Paul Booth, President's Office. And who do we have on the phone today?
Nicole Power, General Counsel. Roger Arts, General Counsel. Michael Hatcher, Central Region.
Great. Yeah, we're going to mute you now. Thanks for your contribution. And let me say a few words about Brother Don.
All participants are now in listen-only mode.
Don was the director of research for, a whole period of time that he's going to tell you about, but starting in 1967 he came to the Union, which would just be about the midpoint between when the Union started and today, roughly, a little bit before the midpoint. I recall also when Don was the executive assistant to the President of the Union during the last year of Jerry Worf's term of office. So there's a vast amount of AFSCME history that Don not only was around for, but actually made and participated in. The buildup of the union's expertise was on his watch and during his one of his big contributions. There are collective bargaining laws scattered around the United States of America that have his wording in them and his brain power behind them. And there's a whole crew of bright people who he figured out how to bring into the union and keep here that some of you know, and that we're going to even hear about some of those recruits, so you get the true story from Don. And it may be a little different from the story that you'd heard, but that's okay. That's the whole point of this class. You're getting unvarnished truth here. You're getting 88, 90, 92, 95% of the whole truth.
I don't know about unvarnished, but
Well, okay, so today may get varnished. So I asked Don to start us off by going back in time to when he came and to give to the best of his ability, kind of description of what the union looked like and where it was at in 1967. What did it look like as a new person coming into the fold at that point in time? So we just have a photograph in our heads or a picture of the union at that point.
well, as a matter of fact, what I would like to do is start a few years before I came. From what I've been told by others. You all know about the founding of the union, and we don't have to go into that story and how eventually the union got its own charter with the AFL-CIO. But, and you know why the union was founded. And so it becomes important to understand the growing discontent that began roughly in the 60s with the idea that civil service was not only the way of the past, it was the way of the future in terms of the best kind of representation for public employees. And some of the dissent, as I say, started in the union through a group called CORE, not the Civil Rights Organization, CORE, but the union group called COUR, which was Committee on Union Responsibility. And it was a bunch of young Turks who decided that, yeah, civil service was fine, but civil service really didn't represent the needs of public workers as well as they should be represented by a union. And the idea was to reform the union and basically turn it into a union organization devoted to collective bargaining, representation, and a solid grievance procedure, of course. And so 1964 was then the culmination of that political campaign that went on, and Worf was elected, and that began in large measure. There had always been pockets within the union that engaged in bargaining and even went out on strike. McEntee's father, for example, was head of the garbage collectors in Philadelphia, and they had a strike in the late 30s. So that in local government, urban areas, there were AFSCME local unions that operated as a union, as distinct from a civil service association. So when Worf came in '64, the union had a very inadequate headquarters because everything was decentralized. The power bases were the local unions for the most part, not even the council. And to the extent that the local unions were not engaged in collective bargaining, many of them operated as clubs, or as I referred to them as banana stands. So it was roughly that time when the union started to reform and rebuild itself. By the time I got here in '67, the union had the reputation that never left as long as Worf remained as president, and that was the revolving door. And it was, in all honesty, it was a revolving door. I don't know how I lasted 15 years under Worf. And there were certainly times when I was halfway out the door. But in any event, he understood immediately, of course, the need to build up the headquarters staff. And when he came in, the first two things he did was he hired an outstanding outside general counsel, a firm. It was not inside, it was an independent general counsel, Henry Kaiser. And one of the few labor public relations firms. And that was also an outside operation. But at the same time, he began to build up a headquarters staff with some expertise, which was, in all honesty, a departure from what had transpired under the Zander administration. In fact, for many, many years, at the beginning, headquarters were not in Washington. They were in Madison, Wisconsin, where the union was founded. So the union's membership when I came was roughly 330,000. AFSCME did not warrant a spot at that time on the AFL-CIO Executive Council. It wasn't until a few years later that Worf was elected to the Executive Council. And that in itself is an interesting story because the union became a very evolved into a very progressive organization. There was a very, very, very tight, close working relationship that began in the 60s, in the mid and late 60s, with the civil rights movement. And much of our organizing was done side by side with the civil rights movement. It was a time of social upheaval in the country, and the civil rights movement was part of the social upheaval that was going on, and also the move to organize the public sector was also part and parcel of that social movement and upheaval. And when I think back to that period of time, you were able to do amazing things that you couldn't do today. I mean, get away with doing amazing things that you couldn't politically do today. We had a strike here in the city about I think it was either 69 or 70, right after Walter Washington was, before he was elected, when he was appointed mayor by the President of the United States. And he had been appointed, I guess, by Lyndon Johnson and whatever the title was, but it was several years before he got home. We went on strike in Washington, D.C. Nixon was president at the time that we went on strike. We had the famous sanitation strike in the city, and that would be virtually unheard of today. There was a very close tie-in, not only with the civil rights movement, but believe it or not, with academia. Academics saw the need for public workers to organize. They saw it as part of the larger social rights and human rights evolution that was going on throughout the nation. And so in many of the states dominated by urban areas with friendly governors, there was appointed the governor's commission to study the idea of collective bargaining for public employees in that state. And who headed up these commissions were the academics, the labor economists, the labor historians that taught at universities in these states. And one of the statutes we'll spend some time on during the course of our discussion today was the Taylor Act in New York that was headed up by 5 very well nationally known academics who were also, some of whom were also mediators and arbitrators in the private sector. It was headed up by a guy, a professor from University of Pennsylvania, George Taylor, who I had actually studied under. And he was the chair of that. John Dunlop was on the committee. Fred Harbison was on the committee. 2 others whose name escapes me for the moment. But at any rate, that led to the passage of the, and it was called the Taylor Act because no governor, Rockefeller was the Republican governor at the time, nobody wanted their name on the act, so they called it after the chairman of the committee, George Taylor. But we had these studies going on in literally dozens of states. Illinois, where Paul was from, had a similar study. Derber, wasn't it?
Milton Derber.
And there were studies in virtually every major industrial state about whether the state should pass a collective bargaining law. And one distinction at that time that was very important was what I would call the depth and breadth of collective bargaining. In local government collective bargaining, we were able to get away with an awful lot in the absence of any statute or ordinance. We called it de facto bargaining. Why? Because we had either the political muscle or the economic muscle to get the mayor to recognize us. As a matter of fact, in New York City, when Jerry Worf was still there, Mayor Wagner, the son of the famous senator, the Wagner Act, Mayor Wagner passed an executive order in the late 50s, issued an executive order. And that executive order was the base of the Kennedy executive order that was issued in the early 60s for federal employees. It was the first executive order, or the first imprimatur of the federal government that collective bargaining was okay. Now, the rights were extremely limited, but you had the right to represent employees under a grievance procedure if you could negotiate a grievance procedure. You couldn't negotiate wages, hours, terms and conditions of employment, but it was that very important step in by the federal government that made collective bargaining legitimate, if you will. If the federal government can do it, why couldn't states do it? Why couldn't local governments do it? After all, federal government was the most sovereign of all. That's the argument we used to get from state governments. The sovereignty of the state government will not permit collective bargaining. We can't give up our unilateral right to set the conditions of employment for our employees. And the sovereignty argument was used just as the Southern senators used to use states' rights to attempt to kill any kind of civil rights legislation that was introduced. And so the union evolved from a union that primarily represented white-collar workers, many of whom were professional employees. In Wisconsin, they worked for the personnel civil service department. If you read the book, you know that story. And by the time of the 60s, it had switched over to mostly a blue-collar union representing city, urban, blue-collar workers. One of the differences, again, is in the cities where the union really had more strength, economic strength and political strength. And they were able to actually negotiate real conditions of employment. Do you understand the difference between rights bargaining and interest bargaining? Rights bargaining is simply when you represent workers for their rights. The grievance procedure. They're discriminated against. They didn't get the promotion. They were faced with adverse action procedures. They were discharged or received discipline penalties of one sort or the other. That's what's called rights bargaining. Interest bargaining is when you engage in wages, hours, as well as conditions of employment. That's what we call interest bargaining. And so in the cities, we were able to, on a de facto basis, in many, many places, negotiate on interest as well as rights. In state governments, it evolved much differently. Until the state actually passed a law, they would, through their good graces, offer the union a modicum of rights bargaining. And what that meant was you weren't even an exclusive representative of the employees, but you were able to represent your members. So that if you signed them up, you could represent them. Or you represented them, hopefully you could sign them up because you saved their job. You're representing them in grievance and arbitration procedures. And in the rights bargaining, what you did mostly was reproduce some of the statutes from the Civil Service Code that went to protect workers, so that at least they were frozen in for the life of the contract. And if the legislature changed the law, at least you had something else for protection until your contract expired. The other thing was, of course, you never were in a hurry to reopen the contract because you couldn't negotiate wages and hours. You could only negotiate your rights to represent your members. Now, as you know, I step back a few years, the first state to enact a collective bargaining law for state employees was Wisconsin. I mean, it's terrible what happened in Wisconsin. If you go back 80 years, Wisconsin was the state that passed one of the first civil service laws. That was an enlightened piece of legislation at the time and was responsible for the founding of this union in order to protect that law from the ravages of politicians who wanted to replace it with the old patronage system. So it's like what goes around comes around. And then that was in the 30s. Then 50 years ago, I'm skipping over the founding of the union, but that's when the union was founded. And then roughly 55 years ago is when the first actual state statute was enacted, 1959, that gave employees the right in Wisconsin to negotiate. So the most progressive state in the union with respect to workers' rights, public workers' rights, turns out to be the most reactionary after 2010. That's just absolutely amazing. What happened over that 50 or 60 year span of time.
Well, let me get you to drill down a little bit more about the state of the national organization in late 60s when you appeared on the scene. WRF started to do things differently. What were the things that were notable?
Well, I mentioned one briefly, was the beginning of the buildup of a national staff. And especially, and I have to confess that most of that effort was put in headquarters staff as distinct from the field staff. And we'll go into that a little more later as the years progress. But the first effort was to demonstrate to the locals and councils that they could depend on the national union for certain activities. Certainly, external organizing was one that the national union engaged in. And as these state laws were passed, they became statewide campaigns that the local people could not run themselves. They had to be financed and run by the national union. The national union, really for the first time, took a presence in representing public workers in Congress. There was virtually no safety net for public employees, that is, non-federal public employees. And so little by little, we were able to get Congress to adopt, for example, cover state and local government workers under the Fair Labor Standards Act. This would never have been able to be done by locals and councils operating on their own. It had to be a national presence, and it happened gradually. It happened step by step. First, educational employees were included. We're not talking about teachers now, we're talking about other educational employees. Then health employees were included. Then the Supreme Court reversed it and said it was unconstitutional, just as it was about to go into effect on January 1st, 1976. And it remained unconstitutional until the San Antonio transit workers case in '83, when the Supreme Court reversed itself by the same 5-4 vote and said yes, it was constitutional. And since then, public workers have been. And what did this do in many cases? In some of the rural areas and mountain areas and deep south, it helped in the minimum wage. But in most areas, it didn't do much in the area of minimum wage. But public employees were exploited when it came to overtime, unless they had a union representing them that could negotiate those kinds of terms and conditions of employment. They may or may not have gotten overtime after 40 hours of work. It was up to the employer and up to the regulations and statutes and ordinances of the time. So it was in areas such as that, the legislative and political activities became much more significant on a national basis. There existed in the early 60s and mid-60s a people program, but it was not very functional. It took many years to get that started, and it helped our councils and locals who did not raise money on their own for federal campaigns to rely on people to support at least the federal campaigns, and in many cases, the state campaigns as well. So that was another area. Our department, for example, would supply information that assisted these new locals, I shouldn't say new, some of them were not new locals, but locals for the first time that were able to begin to engage in collective bargaining and councils, that it was still a time when they pounded on the table, but over the years, pounding on the table became less effective than be able to make a case before the public or make a case in arbitration. And much of that data that they were able to use came from the national union, not their own local resources. So that was another area in which the national union provided visible evidence that meant something in the pocketbooks of workers who we represented. And then this gradually spread. More and more departments were initiated depending upon the needs of the time. I mean, back in when I came aboard, my guess is the headquarters staff could be counted. Well, I guess you would have had to take it off your shoes as well as your gloves, but that was about it. And compare that to today, for example. So I think it was in this area. I guess one other word of explanation is that you look at the labor movement. You have, as a generalization, you have two models. You have the old AFL model, and you have the old CIO model. The CIO model was basically top-down leadership. Auto industry, rubber industry, steel industry. National union did much of the bargaining. They did pattern bargaining. They negotiated with a handful of companies only. And you set patterns in one and brought it to the other and brought it to the other. And the national union had responsibility for that. The AFL pattern was decentralization. The locals were strong. Some of them had state or regional councils, but essentially it was the local union of the plumbers, the electricians, the plasters, whatever, the carpenters that did the negotiations with the building associations. And that's the way the union was organized. This union, by the very nature of our industry, had to be a somewhat decentralized union, and it followed the AFL pattern. But by dint of personality and internal fortitude and smarts, that the union did not change its basic structure, but it did two things that a lot of unions were not able to accomplish. One is by making the national union the end of the funnel, in a sense, for expertise and information, and by a willingness to try to get rid of a lot of dead wood, which politically was sometimes very difficult to do. And by dint of personality, the national union was able to establish a very, very strong power base of its own in dealing vis-a-vis the locals and councils, because it became much more relied upon. And at the same time that this was going on, it was going on in response to the passage of the state laws, which meant that you're going to have statewide bargaining, at least for state employees in many cases. And the organization of state employees, and we'll talk about this a little in a few minutes, was also on a statewide basis. And so the national union was relied on, again, much more financially. And the union was able, in very large measure, to remake itself to respond to what it was pushing for, collective bargaining. Because relying in a state on the old banana stands, if you will, all these little local unions throughout to do the statewide bargaining would be a disaster, frankly. It required much more than that. It required more effort. It required more skills. It required more financial support. And so I'm sure Larry talked about the 1974 constitutional amendment with the dues reformation, which, and I won't go into that except to say that was part of the great changeover in the union, because it enabled councils to assume more and more responsibility once the national organizing campaign was over in the state and the elections were won, and then councils could begin to build themselves and become very strong and self-sufficient, which took place really over the years and became a very important part in the evolution of the union. And I've seen a lot of unions in the public sector, especially federal unions, which were not able to reorganize themselves to respond to the new challenges of collective bargaining. And as far as I can see, or many of which are still in the Alice in Wonderland stage. I mean, they just don't get it. They just don't get it. And so I think that by a lot of hard work and blood, sweat, and tears, the national union was able to prove its value. And certainly, I'm sure that everybody participating in these sessions sees the kind of role that the national union plays in difficult times such as this, which have not been experienced, quite frankly, if ever, in the besiegement that public workers are facing today.
Now, before we go into the organizing drives and the big growth, we talk about the enactment of the organizing laws. Today, it would be unimaginable for there to be a state collective bargaining law enacted where you wouldn't have a picture of somebody from AFSCME in the room, working the language, talking to the governor, making the
Necessary.
Making the deal.
Yeah.
Whether it would be the president himself or a Fantazo or a Kreisberg or a Booth or something like that. But when the first ones were passed, when we were a smaller, the Wisconsin one, the Taylor Act, the Pennsylvania, was WRF, was the research department, was the general counsel, were we in the same relationship to making those things happen? Or was this really a product of these law professors and labor law people who...
Initially, it was, in large measure, it was two things. One, it was, as I mentioned earlier, about the the outside experts, the academics, the arbitrators, the historians, the friendly liberals, whatever. And their pattern, in large measure, was to follow the National Labor Relations Act. That was the model that they used. That was the model that we as well used. In the earliest days of my recollection, to that extent, we were not the major players. We may have had in one or two states someone who was competent in that area and could advise, consult, what have you. But that was relatively rare. And many of these commissions or committees were responsible to build up the political support that was necessary to enact the legislation, whether it followed their advice directly, as it did for the most part in the Taylor Act, or whether there were changes that were made. And as we can talk about later, I think there were some necessary changes between the public and private sectors that also had to be, at least I came to believe that over time. We largely developed that in-house. And over a period of time, somehow, and I cannot recall or remember or say with any assuredness how that started. Where did that evolve from? But I kind of became, I think, the lead person in that area. And I'm not sure how that happened or why that happened, but at any rate, over a period of years, it evolved. And so...
What was the first state law you had your hand in?
The first one that I had I think, substantial influence was in Ohio. What happened in Ohio, we did have a guy on the scene in the, going back before my time, who worked the state legislature and understood this stuff, Tom Morgan. And there was a period of time that, and this is a very weird thing. There was a Republican governor, whose name I have long since forgotten, who served 2 terms. The first term there was a bargaining law passed, he vetoed it, and the veto was upheld. The Democrat came in and was not able to get the law passed. This guy was reelected. A law was enacted that I did spend some time with Tom working on that. And the governor vetoed the bill. I've forgotten whether it was the House or the Senate that overrode the veto. And the other branch of the state legislature was about to override the veto when the Akron firefighters went out on strike. And a newspaper took pictures, one of the Akron papers, took pictures of a bunch of firefighters standing around watching a house burn.
Not good, huh?
And that was the end.
Ouch.
Was a problem.
It took another decade before, of course, the governor's veto was upheld.
Yeah.
And it took another, and that's the second time around, I think, was when I played a large role with Bob Brinza, who was council director at the time, and we actually sat down and drafted the bill, and then turned it over to the committee in the legislature, who put it into Ohio language. Then, of course, the legislature massaged it. They didn't buy everything we did, but it was essentially a bill that the union proposed. The executive order in Illinois was another one that we were responsible. And Bill Welsh was the guy who politically did all of the, did all of the.
That was December 73, or September 73.
But, Governor Walker, right? Governor Walker.
The other
yeah.
Walker.
Yeah, the other Walker.
Better Walker.
The other Walker, the Illinois Walker. Actually, he did. He got to be governor by walking the state.
Yeah, he was a Walker.
Campaign by walking the state.
But with the Taylor Act, that was not one that we had authorship of.
No, that was the committee, the committee of five that drafted that bill. And if you want to, there were very interesting things that happened as a result of that bill. It taught us a big lesson. This was 1966 and 1967, and it was CSEA was an independent civil service association at that time. And every state employee, including the judiciary, belonged to CSEA. The state of New York did not have its own insurance program. If you joined CSEA, you got insurance, and every state employee belonged to CSEA. And when the Taylor Act was adopted, there was an academic there who was a friend of the Rockefellers, and the idea was to have one statewide bargaining unit. This was not necessarily Taylor's the Taylor Commission's recommendation. This was after the law was adopted, bargaining units would be set. The law set forth the idea of the bargaining units. And so they came up with one statewide bargaining unit. We wanted what we called at the time fragmented units. You understand the difference? In other words, the largest unit you went for was the unit you could organize, that, and you call that an appropriate bargaining unit. If you could organize it and it was one institution, that was a good bargaining unit. So maybe we wanted to have 12 mental health institution bargaining units, etc. The state wanted one. Lil Roberts, who some of you know, and many of all have heard about, certainly know by reputation, was with Council 37 in New York at the time, and she was an ex-health worker in Chicago. She came when Victor came in from Chicago to head up Council 37 in the mid-60s. Lil came with him, and as the assistant director of the council. And so Lil conducted, at the behest of the National Union, at the behest of Jerry Worf, Lil conducted some spontaneous strikes at mental health institutions protesting the establishment of this one bargaining unit statewide. and went from one institution for another. One institution would shut down for a day or two and go to another one and shut down for a day or two. And finally, Lil was put in jail, but a deal was reached, and that's where, Worf did play a role in that. That it would be 5 statewide units, what we call horizontal units. A professional and technical unit, you had a correctional unit, you had a clerical administrative unit, you had a health unit, and essentially a blue-collar unit. But all the mental health institutions were major state employers at that time. I mean, 90% of them at least have been shut down since then, but at that time they were a major state employer. And so the deal was cut for five bargaining units. CSEA won 4 of the units. We were basically the only competition. We took the correctional unit. Several years later, CSEA was raided by a combination of SEIU and AFT in the professional unit, and they took away the professional unit from CSEA. And it was after that CSEA and AFSCME merged. And that was in 1978, which was a good decade after the original elections, which took place in 68. But that experience in New York had a very, very substantial impact on AFSCME. And we decided that because New York State was a unique situation in that everybody in the state had already belonged to CSEA, that we had by this time, through a combination of growth and bluster and producing, at least in some areas, we were strong enough to take on statewide campaigns ourselves as a dominant union because we knew who our competition was. And our competition would be fragmented unions. SAIU at that time was a very fragmented union, nothing like the union it is today. The laborers, a fragmented union. The Teamsters, very strong but fragmented. And we saw those unions and some of couple of the other building trades unions, not on a national basis, but given the state could be a player, and as the laborers were in Pennsylvania a few years later. So we switched philosophies completely. Not for any reasons of good government, but it was good. But incidentally, it was good government, or coincidentally, it was good government. We decided we could win statewide elections, and these other guys couldn't. They were too fragmented, and we learned a lot in '68 in putting on statewide campaigns, even though we lost 4 out of the 5 units. And so we became the major advocate of broad horizontal units. We could get down to 1 unit, so much the better. But usually it was somewhere between a half a dozen and a dozen units. But in some of these states that had earlier passed collective bargaining laws, I think it was Montana had like 80 units. There weren't 80 public employees in the goddamn state, but there was 80 bargaining units. Rhode Island, same thing. Oregon, the same thing. Every prison in Oregon had their own bargaining unit. Every hospital had their own bargaining unit. So we became the good government guys. We became the advocates of horizontal units. And the intellectual basis for that was good government. The intellectual basis was if the state was interested in maintaining some uniformity in conditions of employment, in a wage classification system, in a health insurance program, and some cases we were even able to negotiate the retirement systems, then it made sense to have these broad units of people doing similar work irrespective of the agency they worked for, to be represented by the same union and negotiate, if we won several units, negotiate a master statewide agreement. It was the closest thing to civil service that you could get in terms of state organization. It fit right in. And so Pennsylvania is a perfect example of it, was a perfect example of this, which came in 71, if I recall correctly. Probably more units than necessary, but still consolidated units that we wound up representing 70,000 statewide employees. I think everybody except the social workers and state liquor stores and the state troopers. And the state liquor stores, we just made a deal with UFCW and saying we won't go after them. You stay out of our business, we'll stay out of your liquor stores. We probably later came to regret the deal with the social workers.
Yes.
Andy Stern was the local president. And ever since then, I think consistently, as far as I can recall, we went after, and we were very good at what we did because we had all of the rationale for it, and we were able to convince the legislatures in some cases either to write the bargaining units in the law or to write them in such a way that the outcome, to put down the criteria in such a manner that the outcome was obvious. There was going to be a handful of units and no more. And so that enabled us to, as I say, engage in statewide campaigns, and we were the ones that were able to win most of these statewide campaigns. There was something else very weird, and I have only a very limited explanation for it that went on. While this was going on in Illinois and Ohio and other industrial states, we found, without knowing that it was being done, places where we had little or no state members, that, lo and behold, Kansas enacted a kind of collective bargaining law for state employees. It was a half-assed law, but it was a law. Nebraska did the same thing. And the only thing I could think, there was no pressure on the state to do it. The only thing that struck me, and I'm not sure I'm right, was that because of the sweep of laws that were being enacted in the 60s and 70s, these states wanted to control their own destiny. because there was something else going on. We were threatening to get a federal law passed at the same time, and I'll get into that in a minute. And that they figured if they could pass their own law and control the provisions of that law, they would be spared of having to fall under a federal law, or they would show that states are enacting their own legislation and the feds had no business in this area anyway, interfering with states' rights. So you had 3 or 4 of these states, which were relatively rural states, that were under no pressure from within to pass a collective bargaining law, that passed a law. Some of these were changed later. Kansas, for example, and Nebraska were both made somewhat somewhat stronger and more sensible. But at any rate, another one was Florida. The South was a vast wasteland with respect to a lot of things, but including public workers' rights. But Florida enacted a new constitution in the early, I think it was 63. And in that constitution, it had a right to work provision. But the right to work provision also had in it that all workers had a right to be represented by unions. They'd have to join, they couldn't have mandatory union membership because it was right to work was built into the Constitution. But workers had a right, and I think it was the teachers' union that went to court, and the Supreme Court decided yes, but that was a meaningless right unless the legislature passed a law authorizing, mandating the state to have a law in which they would be obligated to negotiate with the union if the union won the election. And if the legislature did not enact such a law, the Supreme Court of the state of Florida would impose standards that the state had to follow in dealing with the union. In other words, the Supreme Court of the state would adopt bargaining standards. So the legislature decided to take destiny in its own hands and adopt a collective bargaining bill that the legislature didn't want, and but nonetheless was passed. It was not a particularly model legislation by any extent, but it was a bargaining law, and that's how Florida got its bargaining. That's how Florida got its bargaining law. So there were some crazy things that happened during that period in states that I have mentioned.
Why don't we give people a chance to throw questions out on the table? And
Yeah, certainly.
you guys got any?
Well, I'll start with I guess a comment. In reading the Power to the Public Worker, I was sort of struck by the corruption within the cafeteria unions where WRF first worked and organized. And it just seemed to me such an odd thing to transition from that into the public sector, because the public sector is sort of defined by lots of, rules and regulations and, systems and way of doing things. And
Well,
it just,
yeah, but keep in mind a couple of things. WRF grew up as a Yipsel, and
Explain what the YPSL is.
young-
Not everyone here
Yeah.
knows what the YPSL is.
Young People's Socialist League. It was limited to New York City pretty well. Jews in New York City were Yipsels, and WRF was a Yipsel. But he was also, he was also an anarchist at heart. And in large measure, some of that anarchy was directed against the civil services rules and regulations. And in some cases, as people who worked here back then would testify, it also showed in his dealings with his own house, AFSCME headquarters, I mean, his own union, I mean, the union of which he was president of. Because in the rare occasions when things were going smoothly, and I say rare occasions because things were just, it was like chaos most of the time. In those rare occasions, Worf stirred the pot because he couldn't take those rare occasions when things were going too smoothly. So there had to be tensions that were established and built up. So he like his successor had an innate ability to communicate, especially to blue-collar workers. It's just amazing how he could not speak down to them, but communicate with them, and they understood that. So there are a lot of contradictions. Yes, I agree with that, but some of them are explainable and some of them are not explainable.
Yeah, Lisa.
This is more of a labor history question, but in the reading, it talked a lot about the CIO being more of a communist culture and the AFL being not, and that Worf was anti-communist. And it's hard to picture what that meant. And could you just give us a little bit of the flavor?
Yeah, I think communists probably, with the exception of a few CIO unions, is an overdrawn term, more of a socialist flavor, like the needle trades, the amalgamated clothing workers, the lady garment workers,
Ruther.
fur workers may be further left, but let's say the distinction that is more frequently used, I think, is that the old AFL unions, especially the construction unions, were kind of known as bread and butter unions. They didn't have, and all of this is overgeneralization, and it's but it bears the kernel of accuracy. They didn't have any kind of progressive vision. The building trades unions spent half their time keeping blacks out of apprenticeship programs, as an example. They were not part of the 60s movement. Many of the unions were much more Republican than Democrat, if I could use that as another example of conservative versus liberal or progressive, and wore their republicanism on their sleeve. Teamsters, food and commercial, and many others. CIO unions were mostly Democrat. The old expression credited to Franklin Roosevelt when he was president was "clear it with Sydney." If there was legislation that had anything to do with social programs or labor unions, clear it with Sydney means check with Sidney Hillman, who was president of the Amalgamated Clothing Workers. John L. Lewis once said to Roosevelt, when Roosevelt decided that one term for his Vice President Garner, was enough, that told FDR that we would make Mr. President, we would make a wonderful team together, you and I, in 1936. And Roosevelt is purported to have responded, yeah, John, but what spot do you want? So to that extent, I mean, there is that, that difference between the CIO before the merger with the before the merger of the AFL and CIO in December of '55, did throw a couple of unions out of the CIO for being dominated by communists. The United Electrical Workers is another example, and they formed, the CIO then formed as a, if I can use the expression, dual union to the UE, the IUE. To try to raid the UE and represent workers at the GEs and the Westinghouses and the other appliance manufacturers, the electric, before electronics, the electric companies, the electric manufacturers, when the U.S. was still a manufacturing nation. And we made our own radios and our own refrigerators and all of that stuff. And so I think that's the way I would have put it, rather than although, as I acknowledge, some communist influence in some unions certainly, but probably more left socialist in some unions.
Don, you were starting down the road to talk about when Worf kind of entering into the AFL Executive Council.
Oh, yeah.
And the whole saga of AFSCME, AFL-CIO relationships that was going to lead us to the Cape story. There's a whole story to be told there that you could help.
Yeah. There are a few stories there. Vietnam was a major player in this. Worf was very much against the Vietnam War from the outset. And some of our councils were passing resolutions against the war. The National Union was very, very quiet. Everybody talked about it, and everybody was against it, but Worf, it was the only subject in the world that Worf had an interest in that he didn't talk about publicly. He talked about it privately, but not publicly. Why? He was not yet on the Executive Council of the AFL-CIO. Meany was president of the AFL-CIO. Meany was a hawk. And on that national affairs, very, 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 very much to the right. Very, very, very strong military. Stopped the communists at every turn, et cetera, et cetera, et cetera. And in the '68 election between Nixon and McGovern, the AFL-CIO stayed neutral. A lot of the unions did their own endorsements of McGovern, but Meany and the AFL-CIO stayed neutral because Meany would not endorse this lefty McGovern.
In fact, the Colorado State AFL-CIO endorsed McGovern.
That's right, and the president was deposed.
Yeah, Herrick Roth was the president of the Colorado AFL-CIO, and Meany put it in trusteeship.
Yeah.
Yeah, Michael?
I was a little taken aback by how, in 1956, when AFSCME merged with the Government and Civic Employees Organizing Committee,
Yes.
and brought in 30,000 members, that within 10 years, Xander would be out, but be out in a lot of reasons because of the sense that AFSCME was always in financial dire straits, the handling of the housing. I was, with such large growth in the 1950s, it almost seems amazing to me that he would, I mean, obviously, other than some of the growing pains of bringing in that many members and different points of view, that he would lose control of the union effectively in under a decade.
Yeah, I don't credit so much with the merger first of all, right after the merger, the president of the CIO Public Employee Organizing Committee left, retired. So there was basically no political upheaval as a result of the merger. They did probably more than AFSCME at that time believe in bargaining. But remember, the campaign for the presidency lasted 2 conventions, basically. It lasted 4 years. And in that time, this union did undergo an awful lot of change in terms of how it saw the future. Yes, there was a lot of blame thrown around for the housing trust thing. Yes, there was a problem of CIA working their way into headquarters building. But that was, I don't credit any of that as being the major dramatic piece of action. I think it really had to do with where the union was going in the future. They were all pieces of it, but I do believe, as I said early on, that this vision of replacing complete dependence on civil service and instead superimposing collective bargaining and considering where our members were at the time and where the bulk of the membership was by the mid-60s, by the time that Worf did win a very close election. I think that had more to do with it than anything else. And I think basically the rump group, the core group, the Committee on Union Responsibility, out-organized the incumbents. Mm-hmm. Right. I think they had more of a cause, they had more energy, they were younger, and they had more of a vision, and I think that played into the results of the election more than some of these other aspects that you mentioned.
Let's go back to the AFL-CIO.
Yeah.
So buttons his lip about Vietnam,
And
gets
he's-
elected to the Executive Council.
Then opens his mouth again.
Okay, so
it took one meeting before he became a vocal opponent to the war and made very dramatic speeches at AFSCME conventions about it and at AFL-CIO council meetings. And as somebody said in the book, I don't remember who was quoted in the first book, Power to the Public Employee, that somebody said, well, I go to meetings to see Worf outvoted 33-1. And that was a typical vote. I mean, that is not an exaggeration. I remember at the 1972, I think it was at the San Francisco AFL-CIO convention, which I do believe was 72. Amazing things happened. A guy from Michigan was the president of the AFT.
Sullivan. David Sullivan.
Selden, yeah, David Selden. And he was a very decent guy, and went along on most things with Meany. He certainly wasn't in opposition with Meany. But he was president. But it was obvious that Shanker was going to run for president at the next AFT election. And he had New York. I mean, that was the, you know, the real power base in the Union. New York, Chicago, Philadelphia were all, you know, major city AFT bastions of strength. And it was obvious that he would probably win the election. And Meany wanted a counterbalance to Worf. And who better a counterbalance to Worf than another socialist who was a hard right socialist? That was Al Shanker, another tough New York Jew. And he was able to get the nominating committee of the AFL-CIO Council to nominate Shanker to get on the council. It was unheard of for a person who wasn't president of their international union, except in those rare unions where the president was really not the CEO. He was the figurehead, like
Cutters and Butcher Workman with Gorman.
and the electricians with the guy whose name began with a K, who was secretary treasurer, and that was
Charles Ballard? I thought it was-
well, the name's not important, but for a non-president to be elected to the AFL-CIO Council. But Meany got Shanker elected to the AFL-CIO Council. And that was, and who was chairman of the nominating council, but Worf's closest buddy on the council, Paul Hall. But he was loyal to Meany. And so Shanker was elected to the council. And
But then
the other thing happened at that convention, let me say one other thing, that happened at that convention, it was absolutely amazing. We'll get back to Paul's question about CAPE, the Coalition of Public Employees. But for the second, it's enough to know that it was AFSCME, the NEA, the firefighters, and the National Union of Treasury Employees, NTEU, an independent union. NEA was going through the same kind of throes as AFSCME, turned themselves into a union from an administrator's outfit. So at the 1972 convention, beside the Shanker incident, there was one other thing. AFSCME introduced a resolution on the floor that for the encouragement, adoption of collective bargaining laws in states for public employees. And also a federal law in the absence of state legislation. And that law should provide for binding arbitration instead of the right to strike. And that was a unique, I mean, that was represented a very substantial change in our policy. Well, Howie McLennan was president of the firefighters, and he was his union was part of CAPE. firefighters have in their constitution a no strike provision in their constitution. Meaning got Howie McClellan to get up on a speech and denounce the resolution that you should use binding arbitration instead of the right to strike to settle public employee disputes. Meany gave up the chair to speak himself against it. That's how much anathema it was to the House. And of course, the only delegation that voted for the resolution was the AFSCME delegation. And the speakers who spoke for it were Joe Ames, who was the Secretary Treasurer of AFSCME, and Jerry Wirth. I think that convention was a very unique one for those two reasons. CAPE was founded in the late '60s as once Wirth was on the executive council of the AFL-CIO. He wouldn't have done it earlier. Because the AFL-CIO was not paying enough attention to public employees and their rights to organize. And Meany, who was an old building tradesman himself, they were perfectly happy to have the building trades organize blue-collar workers who were public employees, occupation by occupation by occupation by occupation. The plumbers could occupy public plumbers. The sheet metal workers could organize public sheet metal workers. That's what they were doing in Chicago when Daley was mayor. And so that was perfectly a reasonable position for the AFL-CIO to take. Well, for us it was death. It was crazy. It was nuts. We had to have an industrial-like union in terms of representing public workers, had to be represented by public employees irrespective of what they did. So that was one way the AFL-CIO was not paying enough attention to us. The other public sector unions that were not ready at that time to go into statewide organizing campaigns and didn't want a state law. SEIU and AFT were the two major ones. And so they were the purists when it came to a statute. And they insisted that any statute that bore the imprimatur of their union or the AFL-CIO had to have the unlimited right to strike. At least we had a modified position before we talked about binding. We had a modified position that until a strike was shown to be inherently dangerous to the health and safety of the community, it would be legal for public workers to strike. It could only be enjoined after it was found to be a danger to the health and safety of the jurisdiction. So, and then from that we went to the binding arbitration, or at least binding arbitration in the absence of the right to strike. And so, and of course, that was, as I said earlier, anathema to the AFL-CIO. But CAPE was an organization that came out of this house, really. Wirth became friendly and envious, if you will, of NEA and the power that he envisioned that NEA could have if it got itself together and acted more like a union, which it was in the process of doing at that time. And the only other union he could interest was the firefighters, for whatever reasons, I'm not sure. And then there was a small, at that time, inconsequential union in the federal sector called the National Treasury Employees Union. No longer inconsequential, I might say, very dominant union in the federal sector now, much more effective than AFGE, for example. And, but at that time, they were not much of a union, but they had two young dynamos in the union. One was general counsel and the other was head of legislation. Bob Tobias, who later became president, and Jerry Klepner, who later became secretary treasurer, and then years later, after Tobias ran him out, he was legislative director of this union for several years, and a very, very effective one, I might say. And times were different, I might also hasten to add.
Yes, thank you.
As Barbara will attest to. So basically, the Cape did a lot of things, but mostly it was a burr under Meany's saddle. Is really, to annoy him. But some of the things that it did and did well was put together information on why there should be a national collective bargaining statute for state and local government employees, especially when state and local governments did not adopt their own. And then we watered it down later to at least have standards. The law should have standards where there was no action. So it had a very dynamic executive director from the NEA, a guy named Ralph Flynn.
And on that point, we actually had a bill.
Oh, yeah, we had a bill that passed the House Labor Committee.
What year was that?
It could have been about 1970, it could have been 69 or 70. I have something which actually, I have the bill, and somebody, probably Bill Welsh, jotted down on the corner, passed House Labor Committee in whatever year it was. But it was roughly 1970, give or take a year.
The firefighters resurrected that and
the police.
Right, and worked on a firefighter and law enforcement bill that we also worked on, and that had a vote on the Senate floor. I can't remember, but Judd Gregg was a sponsor in the Senate, Republican sponsor in the Senate. And this was, I don't know, maybe 5 years ago?
A little longer. The first time it was introduced, because at that time I was chairman of the Federal Labor Relations Authority, and that bill gave Federal Labor Relations Authority jurisdiction over the statute if it ever got adopted. But of course, it never saw much of the light of day. I guess it saw a glimmer of hope. Yeah.
Ralph Flynn.
Ralph Flynn was, as I say, a very dynamic guy. He was executive director of that. And we had hearings, and a bill passed. And I think CAPE and the adoption by a House committee, also, as I remember earlier, I talked about these 3 or 4 states that in the meantime adopted laws where there was no pressure to adopt laws. It was, I think, partly in response to the activity, because a lot of the, I shouldn't say a lot, but certainly some of these states became very concerned. And some of what we used to call the PIGs, the public interest groups, the Conference of Mayors, the League of Cities, the state legislators, what's the county, NACO, and became concerned. And actually it got to the point too, where we talked about academic respect a few years prior to this. academics again became interested in this, and we did some joint conferences on this. And these guys would come up and speak, I don't mean the academics, but the guys from the county and Mayor's Association would, of course, come up and speak against it. But at least we were in the same room talking about I mean, can you imagine today having a serious discussion about a federal collective bargaining law for state and local government employees?
Do it.
So, yeah, why don't you go back and figure out how to get it passed?
Sure.
So I think that accounts for some of these awkward state laws that were, mysteriously adopted during that period of time. But for a few years, CAPE did play a positive role. Of course, it began to dissolve after that AFL-CIO convention with the firefighters taking that crazy stance at the convention. And also in the meantime, what Meany's big gesture to the public employee unions was there was a public employees council in the AFL-CIO, not a department, but a council. And so Meany, Werf kept pressing for a department, a public employees department. But his vision of a public employee department was public employee unions would belong to the public employee department. That means there'd be a half a dozen unions in the public employee department. Well, when Meany said, okay, there'll be a public employee department, of course, they're wound up with 30-some unions. Everybody who had 3 members in the public sector affiliated with the department. Werf envisioned having at least in his talking points, envisioned having a public employee department with setting its own jurisdiction as to who could join, and just like the building trades do. Like the building trades never admitted into its membership the machinists who represented millwrights, who represented construction and erection machinists, because the carpenters represented millwrights, and the carpenters didn't want any. Millwrights and construction and erection machinists did the same work, and they didn't want any competition in the building trades department to let the machinists in with their construction and erection machinists. So it was the same thing. We wanted a public employee department that could set its own jurisdiction, and of course that did not happen. The other thing, the last executive director, Ralph Flynn, went on to California, and he ran the teachers, NEA's largest affiliate in California, the Teachers Association, NEA, which in itself had 200,000 members. CAPE's last executive director was the wonderful civil rights leader, James Farmer, who was the founder of the other Corps, the Congress of Racial Equality, not the Committee on Union Responsibility. And eventually, CAPE just kind of withered away. But we stayed more or less over the years friendly with NEA. And as a matter of fact, we did a lot of no-raid agreements with, or some, I guess some would be a better, more closer to the truth than many, some no-raid agreements in states with the NEA. And now I see that, once again, NEA and AFSCME are allies in many, many activities. So it's interesting again how what goes around comes around.
Yes, it does. Don, now I want you to reveal what led to the hiring of certain individuals.
Yeah, okay.
There's a Lee Saunders and a Steve Fantazzo who's,
And Jim Schmitz.
and Jim Schmitz, whose employment history you could illuminate. Better than anyone.
Yeah. This was in the mid to late 70s. Worf was still president. It was a few years before he died, a few years before McEntee was elected. And earlier, I talked about the building up of staff and how I thought that despite all his foibles and everything else that Worf did, a very, very understood and did a very good job in building up a headquarters staff, even if some of it was at the neglect of building up the field staff. Because once we did that constitutional dues amendment in 74 that went into effect in 76, the idea was to finance the councils better, and some of them can build up then their own expertise and follow in the path of a 37 in New York or a CSCA in New York. I became convinced that we needed to do a better job in building up the field staff. And I thought one of the things we needed to do, we had to hire bright young people, even if they did not have much of a union experience, and do some training of them and prepare them to work for the union as a career, preferably in the field, but maybe they'd find a home at headquarters. And the idea that I approached Worf with was, I'll do the hiring, and I will work with these guys or women for 6 months. And the idea was, we have to concentrate on hiring not only bright young people, but we have to concentrate on hiring women and minorities. And I thought that I was in a position that I might be able to do some recruiting in those areas. And Worf said, yeah, he thought it was a good idea, he wasn't overly enthused, and basically, he wasn't going to pay a hell of a lot of attention to it. I hired a number of people, male and female, some of whom were actually union members, our members. Marilyn DePoy was another product of that hiring. Among those I hired were a guy named Lee Saunders, a guy named Stephen Tazo, and a guy named Jim Schmitz. Lee and Steve came on at the same time. It was in 78. And the idea, I would have them for 6 months and then send them to the field 6 months. And those that cut it at the end of the year, we'd make a decision as to if the director of field services thought they would work out in the field, they would be assigned to the field. If not, then I would have to make a decision whether there was somewhere in headquarters that we would use them, or it just worked out that they wouldn't stay on. So from the outset, I have to say, and there's one other guy which happened a year later. When I became Worf's executive assistant, there was a guy from Illinois that I wanted to bring in as my assistant to headquarters with the same idea that he would work at headquarters and be in this, and then I wasn't going to be around that much longer, and he would either wind up somewhere at headquarters or somewhere back in the field. And his wife had just accepted a job in Washington. And so it was a perfect time for him to move. And I cut the deal with his boss and with his underboss. And that guy was Paul Booth. But that never happened because Worf died. So he came in, what, a year later, 2 years later? When King left.
No, I didn't get here till 89.
Oh, that late? It was,
No, or 79. No.
Forget about it.
I forget.
Yeah, forget about it.
It happened, you had brought, or you or Frank Cowan had brought Heather Booth in
Frank,
to
yeah.
work, to organize mobilization of members for Solidarity Day, for the first
Yeah.
Solidarity Day.
Yeah, that was Frank,
And
yeah.
she was running, which we brought, 60,000 AFSCME members to lead that big.
We were the biggest union in the day, for that day, yeah.
The first, and so that's probably how you found out about me.
So, at any rate, Steve and Lee were, I have to say in all candor, they were all-stars from the very beginning. They caught on immediately. Actually, I also have to confess that Steve was a CETA employee, if you remember or know anything about CETA. He was a CETA employee, and his father had been a firefighter. And I was convinced in my own mind that Steve was Hispanic. That's why I hired him.
That's funny.
Well, I guess right on Lee. So at any rate, that's their beginning, and Schmitz came on a little later. But what happened, basically, the program fell apart because the field service directors in that time, field service changed hands, and I didn't do enough political homework to cover my bases. And one of those guys was convinced I was just trying to place spies around in the field who would remain loyal to me. So most people did not cut it in the field for that reason. I'm still convinced that some of them should have, cut it in the field. But in any event, so that program too kind of withered away. It taught me a lesson, certainly. You got to cover your bases, but look what it produced. Look what it produced. And
Where did this Carrie Corpy come from?
I hired Carrie too, but Carrie was a Midwesterner at heart, and she and her husband wanted to move back to the Midwest. They worked here for a few years, and they wanted to move back to the Midwest and did. But she was able to hang on with AFSCME on a part-time basis in Wisconsin.
Council 11.
Yes, yeah, the virtual non-existent council.
There's a former executive director. He's not virtually non-existent.
Well, at that time, I think it was two people, Terry and Sandy
Bloomfield? No.
Cindy Bloomfield, who was on the national staff, but acted
Oh,
as kind
acted
of
as the director, that's right.
Yes, acted as director, so.
That's right.
So that was, how Steve and so Kerry, what happened was, we needed a successor to me. And I convinced somebody who was, let's see, to bring back Curry. I don't remember exactly how it went, because a few things happened during that transition period.
It was the
But-
Phil Ray and Linda Lane
Yeah,
interims.
yeah,
Yes, no,
that's
you're
why
leaving a
it's-
couple of things out here.
Yeah,
right?
yeah,
Yes.
exactly. So, at any rate, I propositioned Kerry to come back to Washington, and she did, with promises that, that I would be out of there soon, and she'd be in a position to take over. And that's basically what happened, yeah. And I must say that the department now is probably, if not double, damn near double the size that it was when I left.
Well, we probably have time for one last question to Don, if somebody has it, or we can call it a night. Oh, yeah.
I have a question. A lot of the talk about personnel and hiring and stuff makes me wonder, I'm the president of the staff union, by the way, in full disclosure, makes me wonder what were labor relations like here at the time period? I mean, when we're talking about the 70s and 80s.
Remember I said something about a revolving door
Yeah.
earlier?
Yeah.
Labor relations, labor relations were somewhat like that too.
Oh, yeah.
I remember once the staff union, this was not local too, but the
USU.
yeah, USU. USU went out and picketed the building and fired everybody, which lasted about 24 hours and rehired them. Negotiations were something that the actual negotiations were one aspect of union activity that I never participated in, fortunately. And but yeah, there were always rough goes, but there were a lot of requests for resignations, in all honesty. Most of them were, I would say, more with department directors and assistant directors probably than USU members even.
Editors of the magazine.
Oh yeah, boy, that was really a revolving door. Never stopped. Yeah, yeah.
Well, I remember early on, and this would have been in my, I guess, first year when Werf was still alive, and he fired, I think, the public affairs director, Jim Savarese, and then a third person who I can't remember. And you were promoted back up into the executive office, and I hadn't been at. So there was this little party in the research department to send you off, and people were offering you their condolences. I didn't fully comprehend what was going on at the time, but
Yes, you're right. And Jim and I were friends. I hired Jim, and Jim was Worth's assistant, and
Fired him the day after the convention in Anaheim, right?
very shortly there. The Anaheim victim was Bill Hamilton.
Oh, Hamilton, that's right.
Hamilton,
That's
that-
right.
who had been executive assistant from about 74 to 80. And then that's when, in 80 is when '80, it was after the Anaheim Convention, I think, that Jim became executive assistant. And Win Newman was general counsel, and he went too, basically. But to end it on a positive note, I should bring it more up to date in terms of my time, and that's to say that Jerry McEntee, of course, was a very successful president, and administered the union in a much different way than Jerry Worf did, a much calmer way, and whereas Worf would micromanage and then hands off, then micromanage, and then hands off. McEntee was never a micromanager. And you made it on your own or you didn't make it on your own. I mean, it was, although he had a temper as well, he ran a much calmer organization, and one that in his heart of heart and soul of souls, he was not an anarchist. and he did, so it never came out in terms of the organization. It gave me, it reinforced in me the conviction that innately a good institution has this remarkable ability to pick the right leader at the right time. And I think that Worf was a leader for his time because he was a revolutionary. I think McEntee was a leader for his time. Xander, I'm sure, was a leader for his time. When some of them outgrew their wonderful ability to lead at that time. But it seems to me that this organization has had that capacity, and I think once again has shown it. And on that, I'll conclude. Thank you. It's been fun.